Okay, during the break I was saying, as a presenter, I'm always afraid that we're going to run out of material and that I'm awkwardly going to stand for 20 minutes with nothing to say. There's no way we're getting through all this, folks. So I have two things I want to say about residency, and then I need you to tell me. I'm going to make everybody vote with a thumbs up. Do we want to do attendance next? Do we want to jump to SPED next? Or do we want to jump to student discipline next? I think we'll get through 1.5 of those. Just me guessing what time. Attendance. Oh, sorry, I don't have attendance up yet. Attendance, SPED, student discipline. You all think. I'm going to say a couple things about residency while you decide how to cast your vote. I had a comment during the break about Boys Town saying, I've been in a bunch of IEP meetings with Boys Town, never once had the local district involved. I don't want to criticize Boys Town because that's like criticizing, Jesus. But that is a huge flaw in Boys Town's service model, because when the kid is at Boys Town and having success and blah, 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 when he or she goes back home and gets dropped back home, school doesn't know what Boys Town was doing. Kid doesn't, there's no transition plan at all. Now, Boys Town sometimes, 2 weeks later, will send us what they've been doing, but that's no good. Right? Plus, if Boys Town fails to implement the IEP that they've drafted with Fidelity, do you know who gets sued? The local school district. And so we've got the district with the legal obligation and the ultimate responsibility for that kid, and then Boys Town says, nope, we have our system, we're just going to serve him. And so I would love it if you, as advocates for kids, would start saying, where's the local district, why aren't they involved? Because I think that would improve outcomes for your kiddos, and it certainly serves my client's interest. What was the other thing? Somebody else asked me a question, and I said we should talk about that when we come back together. No? Stink. Okay, well, whatever it was, it's gone now. All right, are you ready to vote? Attendance. Special ed. Discipline. Oh, really? Really? Okay, I'll try. Let's cruise through attendance. I will talk faster. This is a great cartoon. No, I like answering. It's better to answer questions and have you really understand a chunk of it than have a slight understanding of all of it. So, all right, you're not supposed to call it truancy anymore. It's supposed to be called excessive absenteeism. Oh, don't even get me started. Because only a judge can call a kid truant. Truancy is a state of criminal activity, so a school and a caseworker can only say excessively absent, which just anyway, whatever. Okay, so we've changed the law on attendance again. I'm just going to hit the high spots here, and we're going to skip a bunch of these slides. So the school now must review the attendance policy annually with the county attorney. Let me tell you this. For the most part, you're going to see statewide, schools generally move pretty uniformly throughout the state. Omaha kind of does its own thing, but still, we all talk to each other, we all do things similarly. The variance between county attorneys' interest in enforcing the attendance laws is wild. I mean, county by county. I have schools with 2 or 3 counties, land in 2 or 3 counties, and we'll have 2 or 3 completely different approaches to the truancy prosecutions. So I think this is an attempt to get buy-in from the county attorney, but I've got county attorneys that say, whatever, just send it to me. I don't have time for this. So there's just very widely differing opinions about that. We've gone back to now the school may report after a student has had 20 absences. Before it was shall report, so now we're back to permissive reporting. This is a big change, and if you haven't heard about this and you work with kids, I want you to know about this. Now, after a student exhibits signs of being excessively absent, and there's no particular cutoff for that, the school district's required to sit down and create a collaborative plan with the kid and the family to talk about how we can address barriers to the student's attendance. I sure think if I were a GAL, a caseworker, a COSA, that I would want to be in on that meeting, right? Because I think you may be the voice of reason between what's happening with this kid. I'm going to skip this. When I talk about the kids' test scores matter a lot whether they're in school or not. That's what these next 3 slides show. I'm going to skip this. Here's that collaborative plan, okay? It has to be attended by the school attendance officer, That person is identified by school policy, so if you don't know who your school attendance officer is, jump onto the school board's policies and find it. The statute originally said a school social worker. Well, you know, the majority of schools in the state don't have social workers. Schools in this part of the state actually have quite a few. But so if there's a social worker, the social worker should attend. Otherwise, it should be a representative of the school, parent or a guardian, administrator, which usually is the same as the school attendance officer, right? They're wearing 2 hats, and then the child if it's appropriate. So that's who should be at the meeting. You guys aren't listed, but there's no reason why you can't attend because the language says at least. So I feel like if you horn in, the school will invite you. Do I have the collaborative? Shoot. The collaborative plan is supposed to talk about, oh, here it is. Talk about what they're going to give the kid. Is that due to the illness of the child? Does the kid need educational counseling? Can we refer to community agencies? Do we need family or individual counseling? Can we assist the family in accessing other community services? Do you know what's missing here? Who pays, right? If the school says really this family needs wraparound services and the family's not yet court involved, I don't know how we get those services to the family all the time. Again, that's why I want, if you're involved with a kid, I want you showing up at this meeting because this looks a lot like a case plan, doesn't it? And if the case plan has already addressed some of these issues, it would be good information for schools to know. All the school attorneys in the state, we've got 2 or 3 different forms that we've created to what this collaborative plan would look like. If any of you want to see what our form looks like, I'll give it to you. Email me. But there's no particular format.
When did that take effect, the collaborative?
Oh, it's July, okay, thank you. I don't know when the unicameral recessed, and I can't do that math. So July 18th. It's for the upcoming school year.
Okay, thank you.
Yeah.
The way we read it, it doesn't tell us when we need to have this collaborative meeting.
The school district's policy should tell you when you need to have that collaborative meeting, okay? So that's going to vary from school to school. Most schools are looking at that 5 absence per quarter benchmark as triggering the collaborative plan time. But that's going to be different district by district. This is a great question. The last thing. This is just a good cartoon.
I think that's
awesome. Reports of the county attorney, which I know you're interested in. The school district may report when the collaborative plan has not worked and the kid's been absent more than 20 days. So if there hasn't been a collaborative plan, you're not going to be able to report. The school district must notify the child's family in writing before referring to the county attorney. And now our inaction as a school is going to be a predicate to criminal prosecution, which I'm not sure that's good public policy, but there you have it. The family's not going to be able to be prosecuted unless the school has met all of the school's obligation. I know. And then this is the exception that looks like it's going to swallow the rule, and I want to tell you about how we're advising our clients to deal with this. The statute has always said this, but they reinforced it in the committee meeting with the attendance people and the Millard moms. And if you don't know what I'm saying there, that's a joke yeah. Because, you know, trips to Europe are the #1, anyway. Illness that makes attendance impossible or impracticable shall not be the basis for referral. That's what the statute says, okay? Illness that makes attendance impracticable or impossible shall not be the basis for referral. What does that mean, right? The statute used to, in other places, say documented illness. They took out documented this legislative session. But we are taking the position, and most schools are, that this makes attendance impossible or impracticable, that I'm not going to say attendance makes something impossible unless a doctor says so. Okay. In fact, I've created a form. We'll see if doctors will sign it. I've created a form that says, I am Joe Schmatz. I have examined this child, and in my professional medical judgment and within my scope of practice, I say it is impossible for child to attend school. Sign here, right? And if doctor won't sign, then I'm taking the position that, you know, that then after 5 or 20 days I can do whatever consequences I need to do. Because where we see, like the kid right before they get to you guys, they're not in school, and mom calls, or when the school calls, mom says, yeah, he's sick, because it's just too much work for everybody to get together and get out the door in the morning. I mean, you know, there are families working with some pretty big burdens. But what we have is parents just saying, kid's sick, sick, sick. And we don't know what sick means. And kids are also sick a lot on Mondays and Fridays. And so we see those patterns as a school, but we don't have great tools. I mean, I have schools that will send the counselor to the school, come on, out of bed. I mean, she'll help the kid get dressed. Well, that's not really the school's job, but so anyway, yeah, Tricia.
Do you see this as a potential, if there's like a long-term illness, for schools to be responsible to contact the parents and say, we need to work out how to provide homebound services for this child?
Yeah, if there's a long-term illness, does the school have to contact and talk about how we're going to provide services for the child? If it's a long-term illness with an expected duration of 6 months or more, that kid should be on a 504 plan. If it's a serious health impairment, that kid should have an IEP. And if it's just that I've got mono, I'm not sure that services for that kind of a student are going to be helpful, but most schools that I know are contacting kids after that number of absence. And that's clearly the spirit of what the unicameral's been trying to do, and that message is getting communicated. Now, I will tell you, did anybody, that Fremont truancy case, did anybody try that in this room involved in that case? Do you know what I'm talking about? Case in the Nebraska Supreme Court where kid had been prosecuted, what? See, yeah, probably, yeah, just in the last 3 months. Kid was prosecuted for truancy, but here's what frustrated me. I represent Fremont, and the court record made it sound like kid wasn't in school, that out of the blue, parents got a letter from the county attorney and they're getting prosecuted, and the school didn't do anything, right? And the school was mad because they looked so bad in that court case. But what had happened is the school had this communication, but we didn't make a good, the county attorney didn't make a good record of it. Not that it's the county attorney's job to do that, but schools hate it when you make them look bad. So I mean, if you don't have any documentation, my strong suspicion is you haven't asked the right person at the school, or you haven't told them what you need, because there's always some kind of communication. I don't know, even the OPS, the biggest, most mechanized school in the district, has a checklist of all the times they've called a kid. I mean, they do respond, but they don't do a great job of getting you all that documentation. Public defenders, this is going to be a godsend, because if they don't have the evidence in the record, keep your mouth shut until the end and say, well, no prosecution possible, because if you say it too soon, they're going to come up with it. So. Yes, I think this law overrules it makes it irrelevant, because now the statute says in its black and white, you must do X and Y before you can prosecute for truancy.
And so basically what you're advising schools then is to still require the documentation, so in effect this law is not going to make any difference. You're telling a public defender.
No, what I'm advising schools is if the family is saying that illness makes attendance impossible or impracticable, I want some documentation that the attendance is impossible or impracticable.
I mean, what we see though is that we have different people determining what they're going to medically document and
right.
what is going to be an IL and what's going to be a PA. You know, kids who have dentist appointments, they bring notes in with a note saying, I was at the dentist appointment, and it's marked as PA or IL, and then it's included in a truancy file.
I don't know PA or parental. What's
illness.
Okay. Well, and yes, and those discrepancies between districts will continue. The school board, as a matter of public policy, is deciding, does a dentist appointment make attendance impossible or impracticable? But now, take off your public defender hat for just.
I'm not saying under that clause, I'm saying for the 20 days, because Lincoln Public Schools, unless it is an MD, and
yep.
only they
yep.
determine whether an MD,
yes.
what it qualifies as an MD.
Yes.
And so we have parents bringing notes after notes after notes
That's
after
right.
note, and they still get filed on.
And really good parents get the letter from LPS saying that your kids missed too much school. But that's not the problem you're getting at is not solved by this statute. But we are talking 20 days, okay? So you don't have to have all 20 of them don't have to be medically excused, but you get 5 of them medically excused, now you're back down below the 20 for the prosecution trigger. So I think that will make a difference. But yeah, but yes, I think the Fremont case in Samantha, if that's the name. See, I know everything by school, right? That I think this it just changes the statute, so it's irrelevant. What's that called? Not overruled by statute, but something like that. Yeah.
So you're telling the schools, are you saying that the schools can determine what's illness, or that the district determines what's illness that makes attendance impossible? Because the statute was written to say that the district sets
Right.
the policy.
Right. Yeah.
The school has to defer to that district.
That's a super sophisticated question. So let me just make sure I'm understanding what you're asking.
Right.
So you're saying that Omaha-Benson should not be able to determine what's excused because the OPS board should determine what's excused. Is that that's the question I'm hearing you ask?
That's how I wrote it.
And I'm not disagreeing with you one little bit. But the board can say, it is our policy to say that you must have documentation for what makes illness impracticable or attendance impracticable or impossible. And then I don't think you're ever going to get it so that the building level principal isn't looking at a note saying, does this meet our policy or not? But I agree with you that the school board sets that policy, and it should not vary from school attendance building to school attendance building. Does that answer your question? Yeah. And I appreciate not many people understand the difference between building and district, so that's why I was double checking to make sure I understood what you were asking. I had something else to say there, and I can't remember what it was. Sorry. Yeah.
So how are you advising your districts in terms of these collaborative meetings that need to occur when you bring all these people to the table, but the parents, for example, won't attend?
Right. How am I advising my districts when we try to have this collaborative plan and the parents won't attend? I'm going to tell my clients a couple of things. One, as an attorney, I want them to document the attempts to have the parents come, and I think we need to try 3 times. 3 feels holy, right? So that's what I'm telling them. And then 2, I think we've probably discovered one of the barriers to attendance if the mom and dad aren't coming to school. So now what does that tell us as a school? Do we need to make a referral to DHHS to the Child Hotline for Educational Neglect? In this part of the state, we'd probably get some response. In the western part of the state, we're not going to get anybody showing up for ever on that one. Does the kid need, so I'm going to tell the school to take the parent's absence as evidence of, okay, now what else can we do? But are we going to be able to solve that problem from the school standing by itself? I don't think so.
But in terms of documentation for referral,
An email, I think if a parent has ever emailed us, I think email can be documentation, a letter. I don't like sending stuff registered mail because people don't pick it up because they think it's a bill collector, right? And I like personal contact, that's documented. Okay. One last thing I'll tell you, and this is in particular for those of you that are deeply interested in this. We've fiddled with attendance every year for the last, 4 years now, and we're still struggling. The way this is written does try to draw on some of the education research about what works for fixing attendance. So I lost myself for about 3 weeks in the education research. I have now written a completely wild and different plan, a policy for attendance that we've sent out to our policy service subscribers as an option for them to look at. It says things like, if a teacher has more than 10% of her students excessively absent in any semester, the principal will meet with the teacher and talk about what's wrong with the teaching that students aren't engaged. Hey, you know what my biggest battle is in getting my high schooler to school? We're not doing anything today anyway, right? And when I was teaching, I'll just tell you, not that I was a fabulous teacher in all aspects, but I told kids when I taught, if you can miss my class and still pass, good on you. But it's my job to make sure that you want to be here every day, right? So one of the key things, and there's no way to get at it in an attendance policy, but one of the key elements of attendance is student engagement. Then the other thing in my policy is if a building has consistent absenteeism, the superintendent has to meet with the building principal and assess school environment. Because the other thing that drives excessive absenteeism, do you see how good I am not saying truancy? The other thing that drives it is building climate. Okay, kids that don't feel safe, kids that don't feel included. But we're not getting at that here either. So if any of you want to see, it's just something I wrote and dreamed up, and I hope some of my clients try it, and we'll see if it works. And then finally, last thing is incentives. Small incentives work. Things like an extra recess for perfect attendance each week it has a bigger impact on elementary school attendance than schools that were giving away iPads for perfect attendance. So small incentives also work. So anyway, that's what we're doing on the school side to see what's happening. We're trying to use a club to change family dynamics, and I'm just not always sure that's going to work. So, okay, I'm skipping all this stuff because we got to hurry. You want this one. 7th grader, this is another, see, it's, you're going to want this. My schools don't want you to see this case. Another SPED case from New York, 2002. 7th grader wouldn't come to school. There were 45 days of school. She was tardy for 11 and absent for 21. Okay, she's not making the honor roll with that attendance record. Grandma called the guidance counselor and would say, sorry, she just won't get out of bed. And the guidance counselor said, well, there's something wrong with her. Maybe you should go get mental health counseling. Grandma then claimed that this attendance pattern, this pattern of being excessively absent, triggered the school district's obligation for what's called child find. The school districts are affirmatively obligated to go out and find kids who may have disabilities, whether that be under Section 504 or under IDEA. So Grandma sued the school claiming a violation of the school's child find obligation. How do you think the court ruled? Dang it, they did. The hearing officer said the absenteeism was a sign of an emotional impairment. It triggered the school district's child find obligation. Again, if you're going to start throwing child find out, don't tell my clients you heard this from me. But absenteeism can definitely trigger child find. Truancy and child find is a huge developing area of the law nationwide. If a kid is gone this much, a school should be asking questions. Oh, that's the other thing I want to say about the collaborative plan. I knew there was something else. In the collaborative plan that I drafted, I include whether or not the child should be referred for a 504 or IDEA assessment, because I think that a kid being gone that much could be evidence that they may have some kind of disability. And so I think schools should be routinely asking that question. That's not part of the attendance statute, which I don't think it should be, but I do think it should be part of the conversation. So those of you that are going to attend these collaborative plan meetings should be saying, does this illness qualify as a disability? Does he need a 504 plan? Because that can change the whole ball game in terms of attendance and services. Okay, now what do you want next? Disability. Now look at that, I did attendance in 30 minutes. Aren't you proud of me? Disabilities? Is that what you want next? Or do you want student discipline next? No. Disabilities, okay. This is I subscribe to a service. I paid $10 extra for this cartoon because I think it's so funny. Okay, this feels like a waste of time, but it's not. I think this history is important for you to understand sort of the jacked up system we have for special ed kids. In 1965, the Office for Special Education Programs was created. That's still the office out of the U.S. Department of Education that bosses us around in terms of special ed laws. Then in 1973, the Section 504 of the Rehabilitation Act was passed. Section 504, if you think of it like this, it will help. It's a civil rights statute, okay? It says, thou shalt not discriminate against disabled kids. It does not say disabled kids get special privileges. There's a different statute that says that, okay? But Section 504 is an anti-discrimination statute. So it's more equality of opportunity rather than a leg up. And Section 504 is still on the books, and it's confusing because we got these battling different statutes. In 1975, they passed the Education for All Handicapped Children Act. That statute eventually became IDEA, and that was the statute that gives kids with disabilities a leg up. 1990, the Americans with Disabilities was enacted. Americans with Disabilities Act was enacted, and people said, hey, that was so awesome that we gave employees special protection. Let's do that for disabled kids. And so there was a sort of a mishmash of the Education of All Handicapped Children Act, the ADA, and then some other stuff, and we mixed that all together, and out came IDEA, that's the stuff that you're thinking of when you talk about IEPs and IEP team meetings and all that stuff. And then the IDEA, every time they reauthorize it, they tweak it. When they enacted No Child Left Behind, they tweaked that again. So this is sort of a moving target for schools, is my point. These trends are interesting. When you are frustrated by schools not having great SPED services, I want you to see kind of from a macro level what schools are dealing with. The number of students identified increases every year. Go back here. When they reauthorized IDEA in 2004, Congress said there are too many kids being verified under IDEA for learning disabilities. Particularly students of color were being verified at a real high rate, and it was all specific learning disabilities. So the reauthorization of IDEA in 2004 added a process into the process for verifying kids called RTI, Response to Intervention. Are you feeling like pushback where schools want to slow down the process of verifying a kid that clearly has problems reading? Are you seeing that? That's what you're seeing there is schools reacting to the RTI. So here's what RTI says. RTI says if I'm struggling in math, then there's like a triangle of services, and the school district has to do all kinds of interventions with me for my math skills before they just go ahead and haul off and verify me as special needs. Okay? So it's supposed to be a break on identifying those kids who are struggling in the classroom as learning disabled. And that's a frustrating trend for you all, and I understand that. It's frustrating for schools too. So, population of students with disabilities peaked in 2004, 2005, and then the RTI kicked in, and we've had holding steady or a slight decline. Currently, it's about 13% of students nationwide are identified as disabled. When I have school districts who really vary from that benchmark, I mean, I've got districts that have as many as 25, 27% verified. That tells me probably they're over-verifying, unless there's some unique population characteristic in their community. If they have lower than 13%, it makes me suspicious that they're under-verifying. Is anybody from West Side in here? Or that they're West Side and trying to keep all the special ed kids someplace else. The categories are also shifting. For a long time, if a kid with an IEP probably had ADHD or what's called SLD, specific learning disabilities. That's just you're not doing a good job in the classroom. So we've had a decline of about a percentage point of all kids nationwide. Mental retardation, absolutely, and it's still called mental retardation, MMR, mild mental retardation. That's a disfavored verification. It's dropped off even more since I put these statistics together. Autism, things on the autism spectrum has just exploded. And the new DSM, the new diagnostic manual for the Sears and Roebuck of mental health disorders, we've gone from autism and Asperger's, and now it's just autism spectrum disorder. I think that's going to lead to more kids being verified on the spectrum. Not good, bad, or indifferent. That's just true. It used to be when a school called about a kid with autism, I knew in my mind I kind of knew what that kid looked like. Now a kid with autism it's a spectrum disorder, right? So that doesn't really tell me much about that kid anymore. I joke to my clients, I'm so old, I remember when Asperger's was rare. And now it's, just not. OHI is the other increasing, exploding verification. That's other health impairment. That's how your schools are going to classify kids with mental illness. And that's, I think, what's driving this tremendous increase in verification. Bipolar, what's it after you've had a traumatic event? Post-secondary PTSD, yep. Those are the things that I'm seeing, just a huge explosion in kids in Nebraska. Is that consistent with what you're seeing? Okay, all right, so with that little history, let me get to the weird way we deal with disabled students in the education system. We have, I showed you the laws. So we have two parallel sets of laws that govern kids with disabilities. Section 504 of the Rehabilitation Act and the Individuals with Disabilities in Education Act. So here's how this works. This blue circle is all the kids that attend any given school district. Everybody put up your hand. Humor me. Okay, put down your hand if you wear eyeglasses, you take any kind of medication, to Ambien, Lipitor, something for blood pressure, anything like that. Put down your hand if you have any kind of what is that called? Acid reflux disorder, arthritis, You've ever had cancer, irritable bowel, anything like that, migraines, consistent headaches. All right, look at the few weirdos that still have their hands up. Okay? Thank you. You guys are good sports. That's these people right here, right? All the kids in our schools that are perfect, have nothing wrong with them, right? Yellow is where most of us are when we put down our hand. I wear contact lenses. I also take Ambien. I also was diagnosed with breast cancer. So I'm multiply disabled, right? So I'm yellow. That doesn't necessarily mean that I get a 504 plan or an IEP. But that kicks me into the category of kids who the school should consider whether or not I need a 504 plan or an IEP, okay? Orange, section 504, are kids who have some kind of physical or mental impairment that substantially limits a major life activity, but yet that impairment is not so severe that it qualifies me under Rule 51 of the Nebraska Department of Education for IDEA services, okay? 504 is going to be diabetes, peanut allergy, asthma, ADHD, autism. Now that autism is such a wide range of kids, a kid could be on the spectrum and not qualify for an IEP, but qualify for a Section 504 plan. Most of the kids you're dealing with behavior disorders probably have a diagnosis from a mental health provider, so they probably would qualify for an IEP. Okay? But Section 504 is a useful area for you all to mine to get assistance for students, even if they haven't met the verification criteria for Rule 51 to get to the IEP. Okay? Now, then the red circle are kids with significant enough impairments that they qualify for an IEP under Rule. So, and when I say Rule 51, that's the state rule that implements IDEA, the federal law. Do you see how the red circle is completely encapsulated within the 504 orange circle? A kid with an IEP also has Section 504 rights. Okay? I can't discriminate against a kid with an IEP. That's what Section 504 says. Now, parents don't get both and. In some cases around the country, courts are allowing a parent to have both a 504 plan and an IEP. In the 8th Circuit, which is our circuit, the circuit I'm clinging to, the 8th has said an IEP is a 504, right? You don't get either or. An IEP is both and. But Section 504 includes things like participating in extracurriculars, and there may be transportation to after-school activities. There are things that might be, a kid with an IEP might be entitled to under Section 504. So a kid with an IEP gets everything 504 would give him or her, plus what IDEA gives him or her, okay? And that's very confusing, both to my clients and to yours. You know, I have parents all the time that are frustrated and confused. But they don't know what they've got. They just know that they're unhappy. So questions on just that general premise? Yeah?
Now, if a parent tries to resolve it through the school and they can't, what's their next option after that? Is there an administrative?
Are we in IDEA or 504? Because the answer is different depending.
Well, for either one.
Okay.
I'm kind of curious, do they go to federal court?
Eventually they can. I mean, actually the trend is plaintiffs' lawyers are leaving IDEA. IDEA has an administrative process. There's hearing officer appointed by the State Department of Education. It's adversarial. Rich Birch was a SPED hearing officer. He's a district court judge now in North Platte. And then if they're unhappy with the hearing officer, you appeal to the State Department of Education, and that appeal is pro forma, and then you can go to federal court. But there's no money damages available under IDEA. There's only compensatory education and attorney's fees, which explains the migration from IDEA to Section 504, right? Now, Section 504 is a federal civil rights statute. There's really no administrative procedure that you have to go through before going to federal court. That's why I would defend all of those by first saying, boy, they should be on an IEP. Gosh, you know what I'm saying? Shove them into IDEA to get myself into the administrative process. But so if they go to if they're claiming violations of Section 504, they can go to federal court. And the 8th Circuit says you can get damages under Section 504. The other, oh God, I can't believe I'm telling people this that are going to call on my clients. But your best enforcement mechanism for 504, if what you want is a fix and not money damages, call the Office for Civil Rights in Kansas City. It's another subdivision of the U.S. Department of Education that enforces the civil rights laws against school districts. They can withhold federal funds, so they get our attention really fast. And a complaint is free. You don't have to be represented by counsel, and then OCR comes in and makes my life hell. I mean, if I was a parent side advocate, I would look up the number for OCR. And don't you dare tell anybody I told you that. And OCR, in addition to 504, OCR enforces Title IX. OCR will look at an IEP complaint under their AGIS of 504. Title IX, what am I missing? Title VII, I mean all the just civil rights stuff. Okay, let me just give you an overview here, and then you can tell me what specific areas of this that you have got questions about. There's a whole bunch of legal steps in the IDEA process. One is schools have to determine whether or not a kid is eligible for services. Really, those are benchmarked. That's a process that's pretty objective, and pretty uniform across the state for the most part. Secondly is identification and evaluation, the process of what tests you give, all that stuff. Then you put together an individualized education plan. I hate it that YRTC is now creating something called an individualized education plan because that confuses me and my clients, okay? An individualized education plan has a real specific legal definition in the school world. And so if you can stop calling things education plan, that would make my life much better. Kids with disabilities are entitled to be educated in the least restrictive environment. I suspect we're going to want to talk about that for a couple of seconds. Parents have specific rights, and then there are specific rules dealing with discipline that we'll talk about at the end. Okay, anybody have specific areas there that you're struggling with, or you want me just to keep marching through the slides? Okay, I'll keep marching. So they have to have a qualifying disability, you know that. Child find is our affirmative obligation as a school to go out and find a kid. A kid that's consistently failing every math class he's taken since 7th grade, and the school has done nothing about that, we have probably violated our child find obligation. And that exists under both IDEA and Section 504. Special ed law is full of, it's like the medical field, it's full of all these abbreviations. So verification is performed by something called the MDT, the multidisciplinary team. That looks a lot like the IEP team, but there might be slightly different people on the multidisciplinary team. I tell my clients every single one of these words matters, okay, for an IEP. Individual, a school that says, this is what we do for our kids with Asperger's. No, you're missing the I in IEP. Education. The school that's focused mostly on what needs to happen at home for this kid to be successful. You're missing the E in IEP, right? It's an education plan. By the same token, the family that comes in and wants to talk about what we're going to do to have this kid play sports better, which we've had, E. Okay? And then the third thing is it's a plan. Okay? It's not our hopes and dreams. It's not the aspirations of our heart. It's, by the end of the school year, Karen should be reading at grade level, God willing, right? That's not a plan. It has to be specific, it has to have benchmarks, it has to be something that it tells us the path we're walking down. And the quality of IEPs in the state varies wildly. Oh, hey, that's the other thing I was going to say. It was SRS. I just thought of it. In Nebraska, every school district except Blair, Doniphan Trumbull, and sadly now Lincoln Public is going off of it. But every other school in the state uses what's called SRS, it's a statewide online system for writing IEPs. So if you're a GAL or a COSA or a parent, you should say, I would like access to my students' records on SRS. And then you can pull up on the computer screen your child's education documents under IDEA anytime you want. And it doesn't cost anything. I have an SRS. I say to schools all the time, put me on the kids' team so I can be an outside consultant, then I can pull up the kids' stuff on SRS too. But so I think it'd be super handy for GALs, public defenders, just ask to be put on SRS. And the address is http iep.unl.edu, I think is the address. But the school will set you up. They control access. Yeah.
So the homeschool is the one that is still doing the IEP. If the child's homeschool
Yes.
is Lincoln, but they're placed somewhere else, is that so? If Lincoln's not doing the SRS, do we not have access to that if they're somewhere else?
So the question is, if the homeschool is Lincoln and the kid's placed someplace else and Lincoln's not doing it, do I not have access anymore? Do you see why residency is such a big deal to me? right? So really, for it to be working correctly, the resident school district should still have the kid on their SRS so that they can give you access and so that we can keep track of what's happening. But Boys Town, and let's just use Boys Town because I've already rudely said things about them. Boys Town has its own SRS, they have access to the portal, and so they'll just set it up themselves, which is stinky because then we kind of lose control. But the great thing about SRS, if you can get on it, SRS follows a kid from school to school. As long as the kid stays in an SRS school system, that's why I wish Lincoln wasn't going off. It lets us track a kid across districts, and it's awesome. They use the same forms, they use the same terminology, it's wonderful. So those of you that work with Lincoln, tell them how much you hate that they're going off SRS. But what Lincoln did is they bought a new software program to track attendance and grades and stuff, and it has a special ed module. So they've gone off SRS to adopt this other module from the new software they've adopted. I know why they did it, I just wish they hadn't. But so yeah, okay, so but in your case, if the home district is not keeping the IEP, you're gonna have to go to whoever, you now know the questions to ask. Say to the school, who's the case manager, who's the district that has the kid on SRS, and then you go to them and ask them to give you access. And it's just, you ask for permission, and then the person that runs it for the school says yay or nay, and they can govern it by building or by kid. Great questions. Okay. IEP team members, can I tell you something? I've told you a lot of places where I think schools are dropping the ball. Folks, this is an area where you're dropping the ball. I'm sorry, but if you represent parents or kids and you haven't been at an IEP meeting, you should change that. Schools want you, if you're nice and not mean to them, you know what I'm saying? But this goes back to that idea that we should be partnering to help these kids. And if you show up at a team meeting without a list of 57 things you're going to sue the school for, because that shuts things down pretty fast. But if you show up and are an active and willing and productive participant in the IEP team, schools like that, and it's good for kids. I have schools who've never, I say, who's the kid's case? Is the kid court involved? I don't know. So I'll jump on justice. Yep, sure enough. Who's the case manager? We've never met the case manager. Look, this person's been the kid's GAL for 7 years. What does he say at the IEP meeting? Never seen him. So anyway, you can all show up. Now, and then can I just answer? Well, let me just ask and I'll do this. Go ahead.
Sure. Does that go for parents' attorneys as well? Actually, that's a great question because I was just going to say the IEP team says, the statute says who's on an IEP team. Has to be the parent. I think I have a slide for each one. Oh, here we go. Has to be the parents, regular ed teacher, sped teacher, district rep, somebody to interpret evaluations, the kid if appropriate, private school representative if the kid's going to a private school, service agency reps, we've got wraparound services, others who have knowledge or expertise. That's where you're going to come in as the parent's attorney. Well, I've tried once to attend an IEP meeting for a parent who I represented, and I was told that I couldn't attend without running it by the administration first, and that they often get pushback.
Well, because they freak out because you're a lawyer. I mean, that's...
But the guardian ad litem, they said, is fine.
Then they're wrong. They're just scared of you.
Lincoln,
yeah, just tell them to call central office. No, don't just show up, because then here's what happens. They stop the meeting. Because I tell my clients, if a lawyer shows up and you didn't know they were coming, I tell my folks, now come on, you can see how you could show up and say, well, the law requires you to do X, Y, and Z, and my stupid school people are going, well, the lawyer said. So it's, I think if you're a licensed attorney and you're showing up at an IEP meeting, I think you should tell the school beforehand. But there is no doubt that as a parent's attorney, you can come. Plus, the parent, that first, includes, like in a little sack coming behind the parent, anybody the parent invited, right? Which I've had ministers, I've had, live-in girlfriends, oh my God. Don't even talk about when the slut that dad left mom for and they all three show up, That's, but if dad brings bimbo, she can come because dad brought her, right? But if you come as an attorney, now just so you guys know, if you're a GAL, I probably won't show up, but if you're a parent's rep and my school says that an attorney's coming, 9 times out of 10 what I do is I either participate by phone or I make myself available by phone so that if something blows up, they can call me. So it's just a matter of being set up to handle the unique issues that are dealt with as an attorney. Attorneys, if you're licensed,
In general, see who's not. No, that matters. I'll tell you why that matters. No, that was not a shot. School cannot have their attorney there as a matter of course unless mom and dad are there represented by an attorney, right? Not an advocate. Advocate doesn't trigger the school's ability to have the school lawyer there, only an attorney. That's why I was saying if you're licensed, not like I think you're all sketchy. And I generally, I've attended a lot of IEP meetings, and I generally think that attorneys can take down the temperature a little bit in an IEP meeting. So I think we help, I do. Plus, everybody wants to behave well in front of witnesses, right? I think even my school people are like, oh crap, she's the one that the board would hire to fire me, so I better not say those rude things. So I don't think having attorneys at IEP meetings is a universally bad thing. Now in California, New York, Connecticut, my colleagues out there tell me horror stories about attorneys behaving badly at IEP meetings. That's not been my experience. In my experience, having attorneys there is generally helpful, and that's what I tell LPS. And I know that the Perry lawyers, I know that the Perry law firm represents LPS, that's how they feel too. Okay, so I had a couple questions. Yeah, Tricia.
There's a certain large school district that indicates to Health and Human Services that they don't have to invite us, that it's the parents' responsibility to invite us.
That's actually true. The question is, it's either Lincoln or Omaha, says that we don't have to invite you, case manager, it's the parents' responsibility. That's technically true, and here's why a school would take that position. First of all, sadly, case managers turn over at an alarming rate. And we, from the school side, we don't have good luck in keeping track of you all. And so we don't know who to invite. Plus, we've also had case managers, no one here, no, people out other parts of the state where they play games. Oh, can't have the IEP meeting because I'm busy then. And then, oh look, I'm only available January 10th. And you want to have a meeting about what's going to happen to this kid for homecoming. You know what I'm saying? So schools have, you play games, we play games, and shame on both of us. I understand especially why a big school district would say, our legal obligation runs to notify the parent, and we don't want to bite off more than we can chew. So that's true, but I think, I will tell you that when schools call me and say, I know there's a case manager, I know there's a GAL, do you think we should tell them about the meeting? I always say yes. Because a family that's involved at that level of services probably needs you. And we as a school probably need you to help us figure this all out. So, yeah.
Just as a comment, when you say that we ought to rethink if we haven't been going to those meetings, I've gone to a number of them as GAL and one or two as a parent's attorney, but I haven't gone for a long time because every time I went, it was like everybody around me was speaking Farsi. and there were so many acronyms and charts that I had no idea what they meant that I couldn't feel like I could contribute.
You want to put a pencil through your eye. Yeah, I understand. I do. So I get that. But if you are a GAL for a kid with behavior problems that's looking at possibly getting tossed, if they're putting together a behavior intervention plan, or if they're ever yitching about how your kid or your client's behaving, I think it's worth you showing up. Maybe you take a file folder of other work to do while they're talking about DIBELS testing and ITBS. I know, and I just speak enough of that to be able to sound like I have an accent, right? But I have sat there at meetings going, the PLEP and the MDT, yes, it's a whole, or you could show up and say, here's the stuff I'm here for. Can we address these things first and then I'm going to dip? And most schools will definitely accommodate you on that. Since you're not a mandatory member of the team, you don't have to stay the whole time. Schools do a better job for kids that they know have GALs. We should treat all kids the same, but we do. I just know it. So that's why I like you to show up. Yeah.
You mentioned advocates doesn't trigger the attorneys for the school district coming. Can you name some of the organizations or advocates that are out there? Because we do have some parents that we need to direct towards.
Nebraska Advocacy Services is probably your go-to for an advocate. The Parent Resource Center, what is that? What is that, Tricia? What? PTI. And the PTI number is on the Notice of Parental Rights that all parents get for special ed. Any other advocates? Anybody knows that? Nebraska Advocacy Center is probably your Disability Rights Nebraska. That's what it's called now. Sorry. Mike Elskin is their general counsel. He does a great job. Well, I don't know if he's general counsel. He's a lawyer that I see. Anybody else you can think of, Tricia? NFSN, I don't know.
No,
No.
it's-
I don't remember. It,
But they're not very active, are they? They like showed up with a big fanfare and then I haven't heard anything from them for a long time. I know the group you're talking
they're
about
going
now.
to court hearings, for some families.
Okay. Okay.
otherwise, no.
I know.
The other thing, and I say this as somebody that has college to pay for. No, I mean, for those of you that are private attorneys, there is a crying need for parents to have legal representation in some of these situations. And Disability Rights Nebraska has real tight restrictions about who they can and can't take. If any of you need a referral for somebody that would represent a parent on a SPED case, I've got a list of attorneys that I do refer to. But if you're a private attorney looking to make a difference, we settle the vast majority. I only take probably maybe 1 or 2 cases to hearing in special ed a year. But it's so good to have an attorney to deal with on the other side. And there are fees. I mean, there is fee shifting if you're a prevailing party. So not that I'm really advertising for somebody to sue my clients, but there's a need for that. There really is. Anyway, I've got a list of about 5 lawyers that'll take parent side cases across the state. If you want that, give me a call. So they have an IEP meeting. Oh, you only have an IEP meeting really once a year. If everything's going well, you're required to have it once a year. So this isn't a huge, I mean, if you've got a caseload of 30 kids, that's 30 meetings, but it's not 30 meetings a quarter, right? The parents have to be notified. That goes back to Tricia's point. It doesn't say HHS, parents. And their schedule has to be reasonably accommodated. You can hold an IEP meeting without parents if the school district has repeatedly tried and the parents won't show up. That's another place where I tell my schools to follow the rule of sacred trinity, try to communicate 3 times. The school district can't predetermine. If you have a school that's saying things like, well, we can have an IEP meeting, but we're going to send them to Boys Town. That's a cue that they're probably predetermining. They have to listen to input from the parent side. Now, some people have interpreted predetermination as meaning the school has to come out without anything. They can have a draft plan, and they should. That's just good time management. But they have to consider parental input. But the same token, make a little asterisk here, because this is a huge misunderstanding about the IDEA. The IDEA does not give parents veto power over what happens to their kiddo, all right? If I have a kid that's consistently, melting down, tossing the table over, throwing chairs, and mom says, I don't want him sent to Brook Valley at ESU 3, the school can say, well, we appreciate your opinion, but we're going to send him there anyway. Mom doesn't have to agree. Now, that triggers mom's right to sue us and take us to due process, which is fine. But I advocate strongly to my schools not to let parents handcuff us and keep us what's doing best for kids, okay? Our obligation under IDEA runs to the student, not to the parent. And so I tell my clients all the time, and you guys, it's true for you too, attorneys have real mixed satisfaction with their jobs, right? But all the research shows that attorneys are satisfied with their job when they work for clients that they like and respect, doing work that they perceive matters. And for us, we have that North Star, right? What's good for a kid? That's what I walk towards. And I can have somebody mad at me for whatever else, but I do what's good for a kid. And that's true for the IEP process too. So if mom doesn't agree, but mom's a drug-addicted mess, we should, even if mom's a really good you know what? I would be a horrible team member for my kids, right? That's like a raw nerve where your kids are concerned, right? So we're the professionals. We got to make the decision for what's best for the kid. If the parent doesn't agree, it's unfortunate. It should make us consider carefully what we're doing, but it shouldn't stop us. Okay. You're used to overruling parents, I guess. My schools kind of freak out when we say that. This is all the Greek that you've heard at IEP meetings. This is what you're supposed to have in the IEP. I'm going to skip this because you don't really care and I want to hurry along. Oh, but this is a big enforcement emphasis nationally, something that you should be looking for your kids that are 16 years or older. We're supposed to talk about the kids' transition to life after high school. What are their post-secondary goals? All that good stuff. And that's a weakness. Skipping this. There, you care about this. Least restrictive environment. We are under obligation under federal law to educate special needs students in the least restrictive environment. The default assumption is that those kids should be in the general ed classroom with typically developing peers. But if the student cannot make adequate progress in the classroom, or if he or she is disruptive to their peers. Let me say that again, because it's different in different circuits. But in the 8th Circuit, a school can move a child to a more restrictive placement either because the kid needs it or because the kid's behavior disrupts the peers' learning, okay? And now, if you get on like national cases, some jurisdictions have said you can only consider the needs of the special needs kid and you can't consider the needs of the peers. That's not true in the 8th Circuit. We can consider both. I always try to tell my schools to have both needs being met when we move a kid. So the placement is determined by the IEP team, preferences for inclusion. You move through, so you start a kid out in the gen ed classroom. Let's say that I'm this kid from Greeley-Walbeck that's been moved all around. So I show up unannounced in Crete. Okay? Crete should start, even though we suspect that this kid is going to be unsuccessful, what this statute says is we should start the kid out in the general ed classroom. And then when he's unsuccessful, move him through a continuum of increasingly restrictive placements until we find the place that works for the kid, right? So here's what it looks like. General ed classroom with nothing or with just supports in the classroom. General ed classroom with pull-out services where I come and get you and take you to the resource room to work on your homework. Instruction in the resource room and just going with the general ed kids to music and art. Full time in the resource room, never going to those other specials. Placement in a school run by the school for special needs kids, like in a level 3 placement within the district. Out of district placement to Boys Town or Best. Homebound placement where I get my services at home. That's the continuum of restrictive placements. Yeah?
Is there a length of instruction time required for homebound?
Oh, I'm so glad you asked that question. No. Now, let me tell you what my school people say. Now, I know what you're saying. Gosh darn it, what do you mean an hour a week at the public library? Are you kidding me? And I tell let me go back. We still have a FAPE obligation to that kid, okay? We are obliged to provide that kid with a free, appropriate public education. And an hour at the library, depending on the kid, and depending on the services, that cannot be our long-term permanent plan for that kid. I do not believe that provides the kid a free, appropriate public education. But now let me flip it around for you. I get calls all the time for do you get these out-of-control little kids, right? The kid that, second grader is kicking over the table at 10 o'clock every morning. And I tell my schools, track, because sometimes what that kid is telling us is, I can only handle an hour of this a day. And so that kid, an hour a day, maybe 100% what he gets FAPE under. So that's the question you're asking. You're telling me you don't think the school is providing this kid with an appropriate education. And that's a whole different legal question that you're entitled to ask about. But you're not entitled to, because what I hear caseworkers say is, hey, he's the school's problem from 8:15 to 3:45. The kid is not entitled to free child care during those hours. But they are entitled to an appropriate education. Now, I've taken these cases where we give the kid an hour a week at the public library as a homebound placement while we figure out what else we're going to do with him, right? It's a place keeping something till we send the kid to Boys Town or we get him into wherever. And I've won those cases, but I've never tried, and I wouldn't try a case where I say, this is our plan for the kid through age 21, library once a week. That's not going to go. And if that's one of mine, we'll talk, because that can't be our long-term plan. Now, homebound instruction can look an awful lot like that, depending on if they're doing Plato or all the computer systems, Nebraska Online High School. I mean, that's actually a good thing, all those options. Yeah, okay. Other questions about that? Gosh darn it, it's 11:05. We were done at 11:30. I don't think you care about this. I'm trying to see what you need to hear. When they transfer districts, the kid takes this is different between 504 and IEP. A kid with a 504 plan, that 504 doesn't necessarily, do you see where I am? Sorry, I'm jumping ahead. A 504 doesn't automatically transfer from one district to the next. If I've got a 504 in Bellevue and I start going to Papillion, La Vista, Papillion La Vista has to do a separate analysis to see if I even get a 504 at Papillion La Vista. So 504 is different, but an IEP transfers with me. So if I have a full-blown IEP, the school district has to comply with the IEP that was in place at the old school until they get a team put together and reevaluate and put together this new school's plan. So that's a big deal for those, because your populations are pretty transient right now, and so that's something I want you to know. Okay, so student discipline. Do you want me to talk about student discipline? Oh, this is just a good cartoon. Special ed questions before we do discipline? Okay. I feel like well, yeah. We just, did Antarctica in 30 seconds. Yeah.
If they're out of home placement, is the home school, they're responsible for if you want to have them tested for special education?
When you say out of home placement, so do you mean that the child's been removed from the home and sent someplace else?
So they're not going to school there?
Have we made a best interest determination?
I don't know. I'm just kind of a weird.
The school of residence, so we're going to have to wallow in 79-215 for a while, but whoever that is, they're responsible for the evaluation. Yeah, that's going to depend on where the kid is. If he's not a foster child, ward of the state, living someplace else, it's going to be the resident district. And what they do is then they contract with somebody wherever the kid is. We do that all the time. Okay, do you want to, okay, so I'm going to do, this is too long. So Student Discipline Act is the state statute that governs what we can do to punish kids. So if you've got any kid that's facing short-term, long-term suspension or expulsion, you're going to want to pull open the the Student Discipline Act, 79-254 to 294. Just so you know, here's these definitions will help you just as you're dealing with kids. Short-term suspension is up to 5 days out of school. Now, in Goss against Lopez, the U.S. Supreme Court said 10 days out of school is when kids were entitled to due process, formalized due process. Nebraska has limited that down to 5. So we're more restrictive on schools in this state than the U.S. Constitution requires. Long-term suspension is exclusion from attendance at all schools from 6 to 19 days. Here's a weird thing about Nebraska. What is more than 19? We can't long-term suspend for more than 19 days. We have to go to expulsion. It's just weird. And then expulsion in Nebraska. Mandatory reassignment is something else that we've done a little bit of, which is where we say to the kid, you are no longer allowed to come to Lincoln. You must attend school in Crete. And then that goes back to that contracting question that we had in 79-215 sub 6. Expulsion is where we exclude the kid from attending all schools in the system. Expulsion generally lasts only for 1 semester with some exceptions. It can be for 2 semesters if it's for a dangerous weapon or a firearm. And it can be for a calendar year if it's a firearm within the definition of the Gun-Free Schools Act. Every so often I have a caseworker say something like, you can't give him in-school suspension, that's against the law. Anything that doesn't require special procedures we basically can do without any formalized due process. So counseling, conferences, changing schedules, you're no longer in biology because you're a bad boy in biology. After school, keeping the kid after school. And right, wrong, or indifferent, there is no transportation obligation. So if we tell a kid you're in detention until 5 o'clock, you missed the bus, tough on you, that's not good education policy, I'll tell you that, but it's lawful. We don't have to provide transportation if we keep a kid in detention. Restricting extracurricular activities. I wish we had more of the kids you work with in extracurriculars because that kicks up that engagement, which solves the attendance problems and it solves a whole bunch of problems. But if you do have the kid that's getting kicked off the football team for drinking, check the board's policy on what, sometimes boards do really unwise and foolish things and make it really hard to punish kids. Harder to kick a kid off the football team than out of school. So always check those policies. We can, by statute, require the kid to get counseling or an evaluation. That makes me real nervous, forcing psychological counseling against someone's will. Plus, I think we have all kinds of IDEA and 504 issues, but it's statutory. Yeah?
On that one, who pays?
School. If we require it, we pay for it. I tell schools, say it, pay it. If we say it, we pay for it. This is just an area where I see schools stub their toes, so I just want you to know they have to have rules adopted that provide reasonable notice about what's prohibited and what's going to be punished. If a school hasn't given, schools are now going to electronic versions of their student handbooks. That's usually where the rules are. If you have a family that doesn't have access to stuff electronically, how have they had fair notice? Okay? And I'm telling my schools to address that and to provide paper copies if somebody says they can't have it. But it's an area for you all as people working with families to think about. I hate to say this because a public defender is going to come and bite me on this, but if a kid's getting kicked out of school, expelled, or long-term suspended, show up at the hearing and look for where the rules are posted. By statute, they're supposed to be published in a conspicuous place. Before I show up for an expulsion hearing, I always call my administrator and say, don't answer any questions, but let me tell you, the Student Discipline Act requires rules to be posted at a conspicuous place. When I get there, I'm going to have you take me and show me where they're posted. Get it? Okay? Because most schools don't have them posted. They just don't know. We can change the rules mid-year, but if we do that, we have to communicate reasonably to families about what we've done to change them. So these are all the stuff that I can see lawyers pulling threads and making life difficult for me. You know what, it is true. Now, one of the things that I tell my schools is, are we rewarding a kid with just what he wants by tossing him, right? Now, the flip side is the school will say, okay, well, you come be the prison warden, right? So we got to find a way to get that kid services and be engaged. I mean, just sticking him in detention in the school building isn't really making him love school either. But yeah, okay, so. Short-term suspension, I have things to say, but I'm skipping all this to try to go fast. For short-term misbehavior, we are not limited to misconduct that occurs on school grounds, in a school vehicle, or out of school activity, okay? I can kick you out of school for up to 3, 4, 5 days for bullying someone on Twitter, even if you tweeted that away from school. Now, I can't long-term, and assuming I can do it consistent with the First Amendment, which is a whole nother, you know, I'll deal with that. That's a whole nother legal question. But by the Student Discipline Act, I can punish for off-campus behavior for up to 5 days out of school. For everything else, long-term suspension and expulsion, it has to be in a school vehicle, at a school activity, or on school grounds. I'll tell you that in a minute. There's no procedure to appeal. We have had Walker versus Bradley. We've had a couple of cases where the family has gone to court. But for the most part, it's 5 days. By the time family gets a lawyer hired, the kid's back in school and it's all over but the shouting. The principal has to give notice. There's a whole, I'll let you read this. This is stuff from the statute. We do have to, in both suspension and expulsion, the principal has to say, I'm suspending the student to help the student. But you know, we can do that. You know, consequences are good. They're a learning tool to further school purposes and to prevent interference with school. Okay, so I want to get to, this is good. So here are the grounds for long-term suspension and expulsion in Nebraska. I'm going to just kind of, again, you've got this in the materials. Controlled substances, including imitation controlled substances. Most of our schools are adding e-cigs and vape pens so that you know it's unlawful for someone under the age of 18 to possess one of those things now, because that had an emergency clause, didn't it? Or it will be soon. So we've added vape pens here, alcohol, public indecency. Oh, this is the only activity that we can expel a kid for if the activity occurs off school grounds, not on a school vehicle or not in a school activity. Attempted or actual first-degree sex assault. If the kid's charged with that, I just generally expel. We'll provide services, but we don't have that kid in the school building for lots of reasons that you can imagine. Bullying now is subject to expulsion. Any other activity which is unlawful in the state of Nebraska, that's the other place that we can toss a kid for having an e-cig. Yeah?
So sexual assault, not a conviction.
That's right. Charge. That's exactly right. Which puts us in a weird spot. We only get 1 semester for that. So I could expel a kid, and he could be back in school before he's ever tried. Or, I had this happen once, found not guilty. Oh crap, come on back, son. Really, technically, we could keep that kid out because he's been charged, but that's not right. But yeah, it does not have to be conviction. The public policy behind that is there were several cases where a boy had sexually assaulted girl. They were in the same English class, and the school said, we can't kick him out of school, and parents were outraged that she was seeing her abuser every day. So that's the justification for that. Yeah?
I've had some schools that have actually, I mean, we're talking like 7, 8-year-olds that are sexually acting out, and the schools become aware of it because it's a small community, and they say, child A cannot come to the school anymore because there's allegations out there.
A 7 or 8-year-old that's sexually acting out, and the school says kid can't come to school anymore. If that was my client, I would say something like, we may need to serve that kid in a more, I would verify that kid. A 7-year-old that's sexually aggressive, that's a verifiable kid in my world. So I would get that kid an IEP, but I would place that kid in a more restrictive placement, because the last thing we need is that kid in the bathroom unsupervised after recess, right? So I would either put that kid in a more restrictive placement under an IEP, provide enhanced adult, I call it enhanced adult supervision, basically someone to watch the kid, or I might even homebound that kid until we can get some psychological testing on him to see what are we talking about here. So all those things would be appropriate and lawful and could sound to the parent like Johnny can't come to school, but you can't simply say sexually aggressive little kid, sorry, we don't do those here. You can't just exclude them from attendance, period. Oh, here's the other thing I want you to know. In addition to that list that's in the statute, schools can also suspend or expel for repeated violation of school rules. So then this is how the kid, I get this call from outraged caseworkers. Well, the kid just dropped the F-bomb and the school expelled him. Well, if he's dropped the F-bomb repeatedly, that can be an expellable offense. Even though it's not listed in the statutory reasons for expulsion, it's under the repeated violation of rules. This shocks me. I still have a few, not mine, but there are still a few schools out there that are suspending or expelling kids for being tardy and truant. The statute is written in a weird way. It says, it is the legislature's intention that truancy and tardiness not be a reason for expulsion. Okay, well, I don't give a crap about your intention. What's the law, right? But I've interpreted that as the unicameral saying, thou shalt not. So if you've got a kid being expelled for being truant, there's a problem there, and you need to work your way up the chain of the school and talk to the attorney, because I don't think you can do that. We don't do it. I don't think we can. Do you care about firearms? I'm going to skip this. Oh, that's a good cartoon. This is all the due process. You can see all that. If you got somebody that's getting tossed, you can pull this and see if the school did everything they were supposed to do. I'm skipping. So let's skip to the slide that says special ed discipline. And then we'll do this and then we'll stop. And everybody can go home and take a Tylenol. Yeah?
I just wanted to ask you a question. I have a lot of my kids down in the detention center. What rights, if any, does a child in detention by court order have to an educational program?
A kid who's in detention by court order, the initial question is he gen ed or sped? Because that's going to change the kind of education that kid gets. That's a question you just need to know to ask it, right? So if my strong suspicion is, I mean, lots of times those kids are verified that are in detention. So if that kid's in detention and he's verified as a special ed kid, he gets everything that's in his IEP. That IEP is crucial. So you're going to want to pull the IEP and say, well, look here, it says he gets 45 minutes of instruction in speech and language every day. Where's that? The IEP is going to zoom out everything. If it's a gen ed kid and they're in detention, still entitled to an education, but just under the Nebraska State Constitution, there's no adjective in front of education in the Constitution except free. So what a gen ed kid gets is a free education. That can be pretty stripped down. 9 times out of 10, what we try to do is to set that kid up, that's a gen ed kid is in detention, with an online learning system. And those systems are good, but they have to be self-motivated, and it's really hard to get the kiddo going. The other option I've considered this quite a bit. This sounds like I'm writing the kid off, but I'm not. What does this kid really need, other than to change his criminal behavior? He needs a high school diploma. What's the fastest route to get him a diploma? GED, that's right. And so even for special ed kids, sometimes what I'll do is I'll say our educational plan as the school is to pay for your GED prep course and to get you your GED. And sometimes if it's a kid on an IEP, he can also get a diploma from my school because it's my plan that has gotten him the GED. But so that's all. A gen ed kid's going to get way less. So verified kid is entitled to a free appropriate public education just like a gen ed kid or a special ed kid at the school.
And a detention facility would facilitate that?
The detention facility should facilitate it, but really the entity on the hook to pay and serve is the resident school district. So we're back to 79,215. That's why that hour and a half wasn't wasted, because that drives so much of what the services are. And I've got a kid in the pen. I've got a kid, is he in the pen? What's less than the pen? No, it's here in Lincoln. It's like some lower security thing, and he got sentenced to 18 months as an adult, but he's young. Anyway, I've got a teacher from York that drives in 2 days a week to serve the kid because that's what we decided we had to do. Great question. Do you want me to try to bang through this in 5 minutes or just answer questions for 5 minutes? Bang? Okay. SPED students may be disciplined. There's a confusion out there among sometimes caseworkers, sometimes parents. Hey, my kid's got an IEP. You can't expel or suspend him. Oh, yeah, we can. For the first 10 days, I tell my schools that those first 10 days are free. We can do anything we want for the first 10 days. Short-term suspend, expel, whatever. How do you count to 10? You only aggregate if the misconduct is related or substantially similar. So if I've got Chew in September and I get kicked for 3 days, and I get into a fight in October and I'm kicked for 3 days, and I drop the F-bomb on a teacher in January and I'm kicked for 3 days, and then I come to school drunk in April, I would take the position that by April, those other ones don't aggregate because it's not the same or similar misconduct, okay? But for you, in terms of working with kids, you need to start counting to 10, and when you get to 10, start asking questions, right? And if the school makes the argument that they're not substantially close in time or similar activity, you can have that conversation. But so 10 days the school gets for free. After 10 days, the school has to make what's called a manifestation determination. It looks like an IEP meeting, basically. And it's a group of educators and the parent and hopefully you. They ask the question, was the misconduct caused by or did it have a direct and substantial relationship to the student's disability? Okay? If I have Tourette's, it's going to be awfully hard to suspend or expel me for dropping the F-bomb in class, right? However, if I have Tourette's and the teacher says, Karen, sit down, and I say, fuck you, okay? That probably doesn't have a direct and substantial relationship to my disability because I'm just being defiant. I'm not just accidentally blurting out a curse word, right? I've got a girl, I'm not proud of my school, came to prom, looked drunk, they sent her home, threatened to expel her, parents got a lawyer, thank God, and lawyer showed up and said, girl has diabetes and her blood sugar was off. Why didn't we ask that question? You know, so of course we're not going to do anything. In fact, I would take the position that it's not even misconduct in that situation. But so that's what a manifestation determination is designed to do, to make sure, to have a check to make sure the misconduct wasn't caused by the disability. Yeah, Tricia.
I have a lot of schools that send home kids or call up parents and say, you need to come and get this kid. What I've told workers, and I think attorneys should know this, is I have told caseworkers that if you are called and said, please come get this child, I want a suspension letter or an assurance that there's a suspension there. Because what schools are doing sometimes is avoiding this manifestation or the additional planning by repeatedly calling parents to say, come get this child. And then what they do is they mark parent approved on the attendance, and then they get turned in for education.
Of course. Oh, I love it. Okay. So the question is, they've got schools that call and say to the caseworker or the parent, come get the kid, he's acting out. Then they mark the kid as being taken out of school by the parent. And then they turn the parent in for truancy or for excessive absenteeism. Okay, I will take my share of blame for that. The kid is melting down, kicking the table over. My people are not equipped to deal with that, in the most part, in most gen ed settings. So I've got no problem with them calling the parent. But you're right, we should either follow up with a notice of short-term suspension, or long-term suspension if we're doing it for more, in which case we start the clock counting to 10. The other strategy that I've used as a school, and you all aren't going to like this, is when we have kids, especially students with autism or other kinds of behaviors, where they get overstimulated and then they freak out and then they might need a day or two at home, I will write into the plan, if Karen acts out, we'll contact mom, and then Karen will spend the next day home to regain emotional control. Okay, do you see what I did there? The rest of that day and the next day don't count towards the 10 because I'm in my educational placement, because I'm home regaining emotional control. But under no circumstances should I be reported as truant. If the school has said, go home and don't come back, we should not be reporting that kid as absent. So I agree with you there. And there are times where a cooling off period is what everybody needs. But yeah, I have no problem with you asking for the suspension or expulsion documents, or to look in the BIP is behavior intervention plan, to look in the plan to see if there's some reason why the kid's being sent home. If the misconduct is a manifestation, we can't discipline, just like the girl with diabetes that came to prom. But the IEP might be changed to address the kid's behaviors, which is my preferred strategy. If it's not a manifestation, we can punish the kid like a regular ed kid, but we do have to provide him or her with services in an interim alternative educational setting, which is the IAES, because we love abbreviations. Okay, we're out of time, and I want to be respectful of your time. I'll stay and answer questions. You've got my contact information. I hope that this has been helpful. If it hasn't been, please tell me. Thank you so very, very much.